Good afternoon and welcome to today's Info Security webinar. I'm Michael Hill, Deputy Editor. I'll be moderating this session, which is sponsored by CrowdStrike. So today we're going to be looking at GDPR myths and urban legends. No doubt you've heard about the impending doom that GDPR regulations will bring after May 25th and how your organisation must prepare to be compliant. However, it might not be as bad as you think, and it most definitely won't be as bad as you've been told. The scaremongering aside, this webinar will dispel some common GDPR myths and will cover exactly what constitutes a personal data breach under the Article 29 Working Party's GDPR guidance. Also, there'll be some guidance on how to respond to a breach in your environment and how you can remediate in the worst case scenario. So before we get started, there are just a few quick housekeeping points from me. There'll be some poll questions throughout the session, so please do take part in those as and when they appear, and we're keen to get your thoughts on those. Also, please do use the questions option to let us know of any questions you might have. You can state on there the question is for a particular speaker, and we'll do our best to answer your questions for you later in the session. Also, for those of you on Twitter, our hashtag is InfoSecWebinar, so please feel free to join the discussion on social media as well. Also, just a quick note about CPU credits. Listening to this webinar does qualify you to 1 credit based on attendance time of 50. That's 50 minutes. Once you've done that, you can download your certificate from your Info Security account and submit it, and there are further instructions on the website for doing that. Please note that certificates will be processed overnight and made available to download the following day. So before we get started then, I will just introduce our panel of speakers. There's myself, Michael Hill. We have Drew Bailey, who is Privacy Counsel and Director of Global Cyber Policy at CrowdStrike. Matt Palmer, Senior Director, Cyber Risk Management Solutions at Willis Towers Watson. And Dee Richards, Services Director, EMEA at CrowdStrike. So just before I hand over to our first speaker, I will start the voting on our first poll question. So we want to know first, how would you rate your current position with regards to GDPR compliance? A, very good, B, good, C, poor, D, very poor, E, unsure. And I'm just going to start the voting on that one now. So that'll be going live, so please do vote on that. And we'll come back to those results a bit later. But moving on, I'll hand over to our first speaker today, Drew Bailey. So Drew, over to you.
Thank you, Michael. As Michael mentioned, I am the Senior Privacy Counsel and Director of Global Cyber Policy for CrowdStrike. So I am both internally handling all of our GDPR compliance as well as externally working with our customers for some of their GDPR compliance needs. And so GDPR is something that I dream about at night and read about during the day, and so it is an all-consuming part of my life right now. But one of the things I want to really express today is that as nuanced and detailed as GDPR is, it might not be as frightening as perhaps it has been portrayed in much of the media, as well as by so many different types of vendors who are right now seeking to solve different parts of GDPR for customers. Today I'm going to focus on the legal aspects related to the data breach notification part of GDPR. GDPR, of course, covers many aspects of data protection, but today we're just going to focus on the myths associated with the so-called 72-hour reporting window. So I'll explain what GDPR actually requires, then we'll go over some of these common myths and debunk them, and then the other presenters will go ahead and walk you through how to respond to security incidents and practical means and what this is going to look like in the new GDPR world. GDPR is often discussed only alongside the concept of privacy, but really GDPR is a holistic data protection regulation. So that in order to keep data that should be private, you need to protect it at all different stages. And then for data that doesn't even need to be private, you still need to protect that data too, with safeguards that are appropriate for the type of data being processed, as well as the risks to that type of data. And so what GDPR includes are several cybersecurity-oriented requirements related to these safeguards, as well as fulfilling the principles of integrity and confidentiality to prevent data from being altered if it shouldn't be altered, and to maintain the confidentiality of data that should remain confidential, as well as an overriding principle of accountability so that an organization can demonstrate its compliance to these principles. As part of the requirements tied to these principles, the GDPR specifies that certain safeguards must be put in place, and that when implementing these safeguards, an organization must pay attention to the state of the art in choosing the right safeguard for the right type of data. What stems from this is that if there is, in fact, a security incident, a breach of security leading to the accidental or unlawful destruction, loss, alteration, or unauthorized disclosure or even access to this information, then there are breach reporting requirements. The breach reporting requirements vary, though. So the common one that people talk about is the 72-hour window, and we'll get into more nuanced detail of what that really means, because it really does depend on the circumstances. As we discuss these concepts today, what we're looking at is the rights of a data subject, and that's the individual, the natural person whose data is being processed. Then the obligations of the data controller, who makes the decisions about the data being processed, and is usually the entity collecting the data to begin with. And then the data processor, which is the organization that's processing the data on behalf of the data controller and pursuant to the instructions of the data controller. The GDPR's data breach notification obligations are in Articles 33 and 34 of the GDPR. Article 33 focuses on when an organization must notify a supervisory authority, whereas Article 34 focuses on when an organization must notify an individual. For Article 33, the obligations are not as simple as they are sometimes portrayed, to where immediately an organization must contact the supervisory authority for all breaches, and if they don't do it in the 72-hour window, then they are in breach of the GDPR. Instead, this new obligation, which certainly is a new obligation, is focused on the fact that it must be a personal data breach, and then the controller must report this to supervisory authorities without undue delay, and where feasible, not later than 72 hours after becoming actually aware of the breach. And this is with regard to when they must notify a supervisory authority. And like with many things in the law, there's an exception. So then there is no notification requirement under this provision if the personal data breach is unlikely to result in a risk to the rights and freedoms of natural persons. And so we'll get into what that means. Whereas the obligation on the data processor is merely focused on an obligation to report to the data controller without undue delay. So there is not a clear specific window of time, and the data processor's obligation goes to that data controller that they are processing data on behalf of. So I wish I had a drum roll sound effect, but here are your GDPR myths. Myth number one, and I see this one all the time, is that all breaches must be reported within 72 hours, or an organization must pay up to 4% of its annual global turnover, or 20 million euros, whichever is more. And the truth of the matter is that GDPR absolutely does have severe penalties baked into it for breaching provisions. However, this is a standard that breaching the GDPR can go up to, rather than this being automatically what an organization would be fined. And also with regard to the data breach notification provision and those specific requirements, not the others, those go up to 2% or 10 million euro. And so it's not the same as this this overall 4%. But even with regard to this 2% global turnover potential penalty, which is absolutely scary, it's not that that's what it's always going to be like, and it's actually something that a data controller has a lot of potential control over before a breach, and even if, unfortunately, there is a breach, because this penalty system is set to ensure that organizations are complying with all of their obligations, taking these seriously, and then doing the responsible things when, when invariably an organization might experience such a breach. So it's really important to know that not all personal data breaches are reportable, and the GDPR is only focused on personal data breaches. So if there's a data breach but the data was not personal in nature, then that's something where the GDPR is not going to apply, even though there could potentially be other laws that would, such as the NIS directive. And then the 72-hour window for reporting does not begin when the breach itself occurs. Instead, it's when the data controller is aware with a reasonable degree of certainty that a security incident has occurred that has led to personal data being compromised. And this comes directly from the recent Article 29 Working Party Guidance, which is from February of this year. And I encourage everyone to at least skim that if you can't get through reading it all. If it's not a good, riveting read for you like it was for me. But the important part here is that awareness does not begin when you're doing the initial investigation. So if you hear that there might be some sort of security incident, that awareness begins when you truly do become aware. Whereas if you are engaging in some sort of willful ignorance, trying not to be aware of any sort of breaches, then you're actually likely violating many other parts of the GDPR. So it's really important to try to know exactly what's going on, and but to keep in mind that the awareness provision is very much a pragmatic one. Myth number 2, all breaches must be reported to data protection officials and individuals. And this is not true either. Instead, as I mentioned, there are provisions for when to report to a supervisory authority, which is not all the time, and when to report to individuals. And reporting to individuals must meet an even higher threshold than before an organization must report to a supervisory authority. So there can be many instances in which something might happen and it's not reportable to a supervisory authority and therefore not reportable to individuals. Then there'll be situations in which you absolutely have to report to a supervisory authority but not to individuals. And the logic there is that if you meet the threshold to report to a supervisory authority, then they might in turn come up with a different interpretation of what some of these risks could actually be to the data subjects, and might inform you that you do need to then inform individuals. Otherwise, they might also say that the reporting to the supervisory authority and the steps you've demonstrated are enough to mitigate the risks to the individuals. And so the rationale behind setting up the provision this way is to prevent people from getting breach fatigue, because we want individuals to take breaches seriously when they're informed about them, but not necessarily be informed about breaches that won't affect them. And so the two different thresholds are whether or not the personal data breach is going to pose merely a risk to the rights and freedoms of individuals. If so, you must report it to a supervisory authority, or a high risk to the rights and freedoms. And that's where there's going to be an obligation to report to the individuals as well. And in considering these risks, there's a multitude of factors spelled out in GDPR Recital 75. And so this is dealing with the types of personal data breaches where that personal data could be used to discriminate against individuals or commit some sort of identity theft, fraud, damage someone's reputation, and do anything else that really is going to cause a high degree of harm to individuals. And so this would be contrasted with a data breach where the information might be so generic that there really wouldn't be anything actionable that could be done, even if the breach itself is reportable to supervisory authorities. Myth number 3, any data that is lost is a breach. And so this is one of these situations where, in fact, you could lose data, but it might not actually be a breach. And so that's why it's really important to fully understand all of the details whenever there is any sort of potential security incident or a loss of data. And so, for example, if an organization lost a portable hard drive and all of the data was backed up, and then the hard drive itself was fully encrypted, and the key to unlock that hard drive was not lost, then that likely would not be a personal data breach, because the data would not have been made unavailable to individuals because of that backup, assuming that that backup could lead to the data being recovered very quickly. And then there would not be a risk to the individuals if the data truly is encrypted using a proper encryption standard, and therefore someone could not actually do anything with that hard drive. And so it's as good as useless, unless, of course, we are talking about evolution of technology. So years from now, that could change to where something that was not a breach might become a breach if something is able to be decrypted. But this is really important to keep in mind. These details matter, and this goes along those lines of how there are going to be incidents that happen that aren't going to be reportable, but will still be breaches, and then incidents that happen that might on their face look like breaches, but might not actually be breaches under GDPR once you take a closer look at them. Myth number 4, along these same lines, another common myth, especially the way that oftentimes marketing materials or some press articles treat these breaches for GDPR purposes, is that all breaches are equal and it's all the same. And that kind of goes back to what sometimes is a bit of scaremongering with those financial penalties. And so the reality is there can be a personal data breach, and it could be reportable, and it could even be reportable to individuals as well as a supervisory authority. And yet it could be something that by its nature is able to be mitigated in a better way, or because of the who may have taken the information, it might be something where the risk and likely impact would not be as great or last as long as if others had it, or an entity is able to regain control relatively quickly. And also, it could be something where it's reportable to both supervisory authorities and to individuals, but perhaps only a handful of people were affected versus hundreds of thousands of people affected. And so that's really going to make a difference in terms of the overall impact of this breach and potential financial penalties for a breach, which leads to the next myth. Myth number 5, that responding to a breach is only about what you do once you're breached. And in fact, these breach notification provisions in the GDPR are really ones that for which an organization should be preparing for by protecting data to begin with and by developing a plan. But then also, if an organization is breached, then it's very important that organizations report any such breach properly, include all of the relevant information about the potential impact, and do the proper investigation to find out what that really would be, and then do all of the proper mitigation that is necessary, as well as preventing it from happening again. And it's work like this that can make what could be potentially a bad breach from a financial penalty standpoint something that could be mitigated, and something for which data protection authorities would actually be less likely to impose severe penalties on an organization. Because GDPR is about imposing responsibilities on organizations for caring for personal data and making sure those responsibilities and obligations follow that personal data throughout the whole entire data life cycle. And so it's very important that organizations are prepared for both before a breach and after a breach to do whatever's proper. And so what this even means is that if there is something that happens that ends up not being a reportable breach, there still is a so-called recording, even if not a reporting requirement under the GDPR. So an organization must still internally document and record what they did for a potential breach investigation, as well as that conclusion that it wasn't a breach. So it's really important to keep track of all of these things, keep track of your data, protect your data, and then ensure you're being diligent about anything that might happen to that data. And so that is the final of these common legal myths associated with GDPR that I wanted to debunk today. So with that, I will pass the baton back to Michael.
Great, thanks so much, Drew. Some really interesting points made there. And again, if you have any questions for Drew, do pop those into the questions section, and we'll try to come to those later. Just before we move on then, I'll close the voting on the first poll question and quickly run over the results. So we asked, how would you rate your current position with regard to GDPR compliance? Top answer, 58% was good. The next top answer, 16% was poor. Then we had 11% was very good. 7% were unsure, and just 5% was very poor. So very much on the positive side of things with regards to that. Okay, just before I hand over to our next speaker then, I'll start the voting on the second poll question. So next we want to know, what do you view as your biggest challenge to GDPR compliance? Is that A, understanding the scope of application, B, the 72-hour deadline for reporting a breach, or as Drew explained, a bit more information there for you, C, appointing a DPO, D, third party or supply chain risks, E, other. And we're going to start the voting on that one now. So that'll be going live, so please do vote on that one, and we'll come back to those results a bit later. But moving on, delighted to hand over to our second speaker, Matt Palmer. So Matt, over to you.
Thank you very much, and it's a pleasure to be on this webinar with CrowdStrike and everybody. So a little bit just to introduce myself, I lead our cyber risk solutions capability at Willis Towers Watson, and over the last 4 years I've been leading our security response to GDPR, amongst other things, as Chief Information. My background's mostly in security, and I've therefore a good understanding of the challenges that GDPR presents. As a leading advisory risk and broking firm, we've got some 40,000 employees in 120 countries. So even with that experience, GDPR has definitely been a considerable challenge. So it's reassuring that 70% of people on this webinar actually feel they're in a good place. Drew has explained, I think, very clearly what the GDPR really means and dispelled some of the common beliefs around it. However, I know that the reality for all of us is that the implementation date is just around the corner. So before Dee talks through the instant readiness implications, I'd like to share a perspective on why the implementation date is not what matters most at this point, and how an integrated approach can help meet your GDPR requirements and minimize the impact of a data breach. So first things first, I'd like to tell you a little bit about how we see the response. We undertook a survey last year looking at companies across the UK to understand how ready people felt for the changes that were forthcoming, including the GDPR, and the outcomes of this were really interesting. So first of all, it's very clear that whilst companies feel that they're in a good position in terms of the support they've obtained for GDPR readiness and their readiness for data privacy, there are still challenges that companies are failing to meet. So in particular, people feel a considerable challenge around budgets, they feel a challenge around how their different functions across the company integrate, and feeling better around legal aspects of GDPR or the technology aspects of GDPR. This presents a particular challenge in terms of response when you consider the complexity of some of the changes that are required. And we're seeing that now in terms of the response to this, and people recognizing that GDPR is as much a business, a data, a process, a readiness issue as a technology one, and a change in where people's focus as a result of it, moving away from technology and towards processes, and also the human aspects of readiness. Having great technology solutions and capabilities isn't going to help you if your people are going to generate issues that are then going to cause incidents that are going to expose you to risk and potentially to fines and reporting requirements under the GDPR. And one of the most interesting things here is that whilst companies feel they're in a good state, very often employee behaviour lags behind. So I've presented just some basic facts on the slide that you see in front of you. We do know that whilst companies feel that they've grappled with this issue, our employees still feel that they're struggling. So in many cases don't understand the behaviours that they need to implement in order to maintain an adequate level of cybersecurity. This has inevitably implications on GDPR readiness, because as a company we can feel quite confident, we can feel very positive about the work that we have done, and yet still not recognise sometimes the complexity of this and the different aspects that have to be in place here, going way beyond technology and legal response. And this is maybe the key of the matter. One of the things that we wanted to understand was what sort of investments people are planning to make in cyber to respond to these types of issues in the environment. And in particular, one of the things that we noted is that everybody either is doing something or planning to do something about most of the key areas that are required to be GDPR ready. However, a lot of this is expected to take a considerable period of time. So as we went and talked about this in recent months, we found that many people feel that these issues are going to take years to respond to, much longer than the GDPR implementation date that's coming up. As a result, a focus purely on the GDPR readiness date is not going to help. So why is this? Why is it that we still have some issues here, and why is it that this is complicated, and how can we maybe look at this a little differently and make sure that once we get past this date, we're still in a good place and we can continue to implement effectively the controls that we need to meet it? And some of this is because the response to GDPR tends to sit within a few specific areas. So very often the company will have a strong technology response, and their security function, the likes of the function that I've been leading for the last few years at Willis Towers Watson, will very often focus on the technology aspects. Legal and compliance functions are deeply involved here and will make sure that we've addressed the compliance issues, the need to report, the need to make data available, make data accurate, not process data that we shouldn't be, or for purposes that we shouldn't be processing it. Very often organisations are looking to do considerable amounts of data mapping and to understand the assets that they have. And often it results in a requirement to review the processes that are operating within an organisation. However, there are a few areas that often get a lesser degree of focus, in particular looking at this as a risk rather than a compliance issue. GDPR is a principles-based legislation. It's very difficult to get to a point where you can say black and white, I do or don't comply, in a modern organisation with complex processes and complex value chains. So we have to look at this as part of our overall risk response. We often don't look thoroughly at the people response aspect of this. So as I was talking about on the previous slide, even if we have the technical capabilities to respond to GDPR, are our people ready? Is our organisation going to respond the way we think it's going to do to the processes and procedures that we've implemented? Finally, testing. A lot of this is quite theoretical at the point where it's implemented. And very often we see less focus on actually testing to ensure that this is going to work and that the processes that we're putting in place are going to be effective. So implementing incident management tools and technologies is great. Have you really tested that process through from identifying an incident right all the way through to communicating this out to boards or even externally outside your organisation? And that results in the number one question that I'm getting today, which is really a do I need to panic question. The answer to this question, fortunately, is fairly simple no. And the reason for that is straightforward, which is even though there are a lot of requirements here and not everybody's considered all of these, we still have the opportunity to get this right. The fact that an implementation date is coming up doesn't mean that a GDPR project closes or the work on this needs to stop. What it means is that we need to operationalise, and it means we need to take this forward in a coordinated way. When we look at how the ICO is seeing this, we can see this quite clearly. There are a number of different areas in ICO guidance, and they're highlighted on the slide in front of you. And very often many of these, they link into this legal response, the data, the technology infrastructure and the processes. Some of them also link into how we manage our organisational risk or how our people respond to these requirements. So in order to be GDPR compliant, in order to maintain that GDPR compliance, we can't afford to look at it as just a technology issue or just a legal issue or just a process issue. We've got to look at those wider areas as well. So what I'd like to do is I'd like to discuss briefly how you can approach GDPR in a way that brings all of this together. And the first thing I would like to make clear is we need to forget the fact that there is a date coming up in which GDPR is technically implemented. The readiness for this, it is never complete. So once that date happens, the law is in effect and we need to be able to manage it. But manage it means maintaining and developing and improving our visibility of our data, our knowledge of our data, the systems that we have, the processes that we operate, and our response to all of that on an ongoing basis. So it needs to move away from being a one-off implementation exercise to being an operational capability that's embedded within the company. And this is the key. It really is an ongoing process rather than a one-off objective. And at the moment, of course, we are very focused on that objective, but now is the time to start thinking beyond that date to how are we going to manage this on an ongoing basis? How are we going to target our investments? So we know that investment in cybersecurity is increasing rapidly as a result of GDPR requirements. According to our own research at Willis Towers Watson, people have indicated that they need to invest in about as many areas again as we are already. We expect investment to increase dramatically in areas like incident response, data understanding data, even post the GDPR deadline. So that means we need to make sure we're making the right investment decisions. And that means aligning our response as part of an overall risk management approach and not having it as a standalone GDPR compliance program. The GDPR compliance program takes us to a certain point, but after that point we really need to align it with the many other rules, regulations and legislations that we have to implement. In some cases, for some companies, that can be hundreds. So bringing it all together into a single risk management discipline so we can make the right decisions. So how can we make those right decisions? Well, firstly, we can understand and if we can quantify the level of risk that we've got. What do we expect to actually happen if we do end up with a data breach under GDPR? Taking into account what Drew was discussing earlier, this is not a need to panic, it's a look at it and say, objectively, based on how ready we are, what could happen? And what are the costs of the controls that we need to implement, the cost of the incidents that we could take place, so we can make sensible decisions, communicate them to our boards, and get the buy-in for the changes that we might need to implement. Security functions to do that, they need to connect the data to the technology. And what I mean by that is very often we look at it as a technology issue. And actually it's a technology issue, it's a services issue, it's a data issue, it's a business issue, and we need to bring all of that together and not look at it in a siloed approach. And the key to that is really to focus on the aspects that have maybe been underemphasized as part of GDPR. Particularly to focus on how are our people going to respond to the controls we've got in place, because without that we simply don't know whether the controls that we've implemented are going to work or not. So how do we test that? How do we ensure people are ready? How do we have the right culture so that people understand what GDPR is there for, not from a compliance perspective, but more from a, well, how is it that I need to behave? Why does this legislation exist? Why is data important, and really understand why protecting that data is absolutely key to the company's success. It is of course possible to transfer some risk. So being realistic, we all know that at some point an incident is likely to happen to us. Those of us who've been CISOs live with that every day, so do board members and many others across the company. However, that doesn't mean that we need to accept it. So one of the things we can consider is actually, are we able to transfer some of that risk? However, even if we transfer risk through insurance or through other means, the reality is that those incidents are going to take place. What that means that having put all of this in place, having made sure that you know what your data is, you know what your processes are, you know how your people are going to respond, you know how that reflects your risk, and you've put in place the right measures to protect, detect, respond, and if necessary, transfer your risk. The key to it then comes down to incident readiness. Incident readiness is the largest determinator of the impact of an incident. It won't determine whether it will occur, but it will definitely define the impact of it and how your company is perceived afterwards. And that's the area where I'd really like to hand over to Dee, who'll be able to talk about incident readiness and response.
Great, thanks Matt. Really great presentation there. And again, any questions for Matt from the audience, please do pop those into the questions option. Just before we hand over to our next speaker then, I'll close the voting on the second poll question. So we asked you, what do you view as your biggest challenge to GDPR compliance? Couple of slightly mixed answers. So 39% was understanding the scope of application, 37% was the third party or supply chain risks. Then we had 6% going for appointing a DPO, 4% for the 72-hour deadline, and just 12% went for other. So just before I hand over to our next speaker, I'll start the voting on the last poll question. So we want to know, do you think there's too much hype about GDPR and not enough useful information and guidance? So we'll start the voting on that one now, so please do vote on that, and we'll come back to that later. But handing over to Dee Richards now. So Dee, over to you.
Thank you, Michael. Hello, everyone. My name is Dee Richards. I lead the services business for CrowdStrike in EMEA. So really, we provide incident response, readiness and assessment services and help customers really mature their security operations. Now, in my presentation, we are going to be looking at, we're going to pivot slightly and look at tactically what an organization should do in the event that there is a breach that you need to handle. So the first aspect to consider really is how is it that your organization is actually made aware that there has been a breach? Of course, what you don't want is to find out when the data you held is already in the public domain and be informed by it by a third party, the regulator or the data subject themselves. So ideally, you're made aware ahead of time by your SOC and your internal controls. So to that effect, it's worth investigating in the first place. Do you have the capability to alert you of a breach in a timely manner? And particularly for high severity incidents and breaches where you may end up having a reporting obligation, it's important to note, are the right people in the organization made aware? Because often it's not just the technical responders, but of course other stakeholders such as your legal, the executive teams that need to be part of that response and mitigation plan. One thing that we often see and find is that SOC teams suffer from the infamous alert fatigue. And the often complex technology stack means that there could on any given day be hundreds of security alerts. And so do you really have the capability that can help ensure that you're able to identify, escalate and triage the critical alerts quickly and in a timely fashion? Now, once you are aware that there is a breach, the next steps really should be to determine the extent of that breach and initiate your response plan. And when determining the extent of that breach, I'll say the most important step here is really to know what data is in question. So is it data like names and addresses, so simple data? Is it behavior-related data such as location, etc.? Is it financial data like card information? Or indeed really sensitive data related to someone's health or other preferences? Needless to say, it is a good idea to have all this data mapped in advance that clearly outlines what you hold and where it is. Determining the extent of the breach in the process should also answer some other key questions like what volume of data is in question, and of course what's the timeline of the breach that you need to handle. Now, as Drew pointed out before, not all breaches will be reportable, of course, but to determine whether that's the case, you will need to look at the severity of the data breach by performing some level of impact analysis on that particular incident. So the question becomes, how do you determine the impact of a breach, particularly on the data subject? In addition to knowing exactly what data about the subject was breached, it's important to look at other context around it, and that becomes really critical. So for example, is the data in question, would it be publicly available anyway, or could it be obtained easily from other public sources as well? Was it accurate, in fact? So is this old information or current information about the subjects? How easy would it be for someone to uniquely identify that person with this piece of data? And finally, look at, if the intent itself was malicious or not. So to that context, let's look at a couple of examples. Let's say somebody in your organization sends out technical information about one of your customers to another customer by accident. You are alerted of this breach, you contact the customer to whom the message was sent in error and ask them to delete it, and of course they do. The impact here to the customer whose data this was is actually minimal. On the other hand, let's say the same piece of data is obtained by a malicious actor by actually breaching your environment through a targeted effort. The impact on the customer here is likely to be high in this case because the adversary is almost certainly going to have malicious intent and potentially cause harm to that customer. Now, let's look at another example as well of a data breach. So, for example, you're an e-commerce company handling large amounts of credit card data, and a malicious actor has breached a part of the network and obtained some information like card numbers, but just the numbers themselves and not the full details that would enable them to execute transactions. Now, clearly, this is again a lower impact than if all details were disclosed. However, and this is key, if the actor then pivots within the environment and manages to breach the database with full card details, then you might have a bigger problem. But of course, as Drew was talking about before, if you have controls like your database itself is fully encrypted and you are still in possession of the keys, it impacts the scoring and likely the breach is not reportable. Now let's look at the technical investigation itself. As part of your initial investigation and as your response team start to do the initial triage, there are really some key areas you should focus on and key questions you should be looking to answer. And those are really when exactly the breach started, which precise systems are impacted in terms of, for example, the hosts themselves, the servers, the network, how was it that the data was accessed, so which specific accounts or level of privilege, etc. And if data was exfiltrated, pinpoint exactly where from, if it was moved, how that was possible, and so on. Now, at this point, I can't stress enough from a response standpoint how important having full visibility, so as close to 100% as possible, is to an investigation. So even if you are relatively confident that the breach is contained within a certain part of the network, to get the assurance that the attacker hasn't pivoted or staged data elsewhere, you really need to be able to pivot your own investigations quickly from one part of your network to another. And often what we find is that specialist forensic technology really helps here. And you'd need expertise in order to collect that metadata, log information, and forensically relevant information and analyze that to give you the specific answers around the questions we talked about. Obviously, once the scope is known, the remediation tasks become straightforward, and they could be containing the impacted systems, removing the malicious files, disabling compromised accounts, etc. All of obviously depending on the nature of the incident itself. Now, through this investigation and process, the response process, you're bound to find out if the previous safeguards and controls you had were effective or not, and to what extent. But again, as Drew mentioned briefly earlier, from a GDPR standpoint, it is imperative that you can demonstrate that you actually did deploy appropriate controls to mitigate the impact before the actual incident, and that during the incident you acted quickly and documented what you did. Now, let's look at some best practices from a security operation and incident management standpoint. And truth be told, what you see here in terms of practices are not all specific to GDPR, but things that organizations should consider anyway to mitigate risk and be more effective in their response. Firstly, of course, Matt pointed out earlier as well, ensuring that your security program is data-centric is key. So really having a clear map of what data you hold where, what the workflows are for that particular data, and what is the potential impact of a breach on the data subjects. So having this pre-assessed and documented will actually go a really long way in speeding up your response. Your controls, of course, should then map to the types of data and that potential impact. So for instance, if you're an organization that holds medical data, you may want to use a control like encryption, as breach of that type of data is likely to have quite a high impact in many scenarios. But flipping it on its head, depending on the type of your business, you may not actually need to encrypt everything. This is something we see quite often where organizations revert to encrypting everything, and that often turns into a quite an expensive strategy. Now, in terms of the plan itself, obviously it's critical to have a documented incident response process, playbook, and plan. And this needs to clearly outline who will do what and how, where the escalation parts would be should a breach actually occur. And a subset of that, which is of key importance, is how the incidents are actually categorized and making sure that your responders are skilled enough and have processes in place to respond effectively to not just commodity stuff and commodity malware, but targeted, sophisticated attacks that might have evaded detection using conventional tooling. So you'll clearly need to execute on that plan quickly in the case of a breach, but really testing the readiness of response before the breach actually happens will mean that you can be even more effective and likely much quicker in your response during the live event. So effectively, don't let the actual breach be the first time you test your capabilities. And to that effect, things like tabletop exercises, red and blue team exercises are great tools to have in your security program. From a containment standpoint, containment and remediation, but at speed, are really the ultimate goals of your incident response. And so once the scope and extent is fully understood, and that needs to be at a high level of confidence, pivot to the response. So contain the host and follow with other remediation tasks. A key aspect here is really having contextual threat intelligence about the indicators you're seeing during a response, and really that should be guiding your response effort. Finally, as Drew pointed out, reportable or not, the breach needs to be documented. So your findings should include everything discovered during your investigation and what you did from a response standpoint to mitigate the impact. And finally, let's look at, or continue rather, on the theme of being prepared. What you see on screen here, really from our perspective, are the core components of the security operation. Needless to say, the more effort that goes into readiness, prevention, and detection, the less the likelihood of an actual breach and needing a response as well. And readiness really is centered around looking at your current state and testing how you would actually respond during a breach, but obviously ahead of a breach. But even before that, it's key to look at, do you even have basic security hygiene? So for example, do you have visibility of all your assets, knowing what is running where, and that critical data map? Do you have things like vulnerability management programs, and do you execute penetration testing regularly? Do you have threat intelligence to guide your operations? Now here at CrowdStrike, as I briefly mentioned earlier, we're able to help customers assess their readiness through services such as proactive breach assessments. So what that entails really is looking at the entire environment and network to determine, is there already a problem? Is there already a breach somewhere? Or are there other security issues that need to be dealt with? We're also able to help customers determine how mature they are in various key areas of security, such as hygiene, prevention, governance, which is a critical component, and response. And finally, just to point on penetration testing, it goes some way in testing readiness, but really in reality, most penetration tests will not mimic real-world actor tactics, and so really consider tests that emulate real-world actors and adversaries, and so actively test your response. So again, I go back to, tabletop exercises are extremely useful in getting your responders, your executive teams, your legal teams, basically the key stakeholders together, and test the live situation, so to speak. On the prevention side, of course, we're all security professionals, so we know there is no such thing as 100% prevention. But again, having good security hygiene like AV capabilities that will block known threats is key. In your detection stack, you're likely to have that defense in-depth concept, but really make sure there's focus on, not just detecting the known bad, so signature-based threats, but really having the capability to detect abnormal behavior. Now, some EDR capability will provide you that, but one of the key aspects we recommend to customers within their security operations is proactive threat hunting. So this is, get your analysts to leverage threat intel and actually proactively analyze any abnormal behavior so they can pick up threats and not just rely on tooling and alerting. And finally, on the response side of the equation, some of the previous capabilities I mentioned, such as EDR, contextual intelligence, and threat hunting will certainly speed up your efforts in the event of a breach and remediation. But timely response and investigation can often require additional expert capabilities. So, extensive analysis of forensic data, for instance, quite a deep understanding of threat actor capabilities and how they apply to your environment. So consider, partnering with specialist incident response firms. Effectively, the benefit there is, you can call them in really quickly for a response in case the worst does happen. So just conscious of time as well. That is all from me in terms of the slides. Michael, I shall turn it back over to you.
Great. So thanks so much, Dee. Really, really great presentation there. So looking at the time, we have a few minutes left. What we're going to do is just read out the results of that third poll question before we look to tackle a few of your questions. So we asked, is there too much hype about GDPR and not enough useful information and guidance? 69% said yes, 18% said no, and 11% were unsure. Okay, just looking at the questions that we've had come in then. Drew, let's go back to you. One of our viewers has actually asked you, they said they're based in the UK, but they're hearing a lot of chatter from the United States, mainly with the view that there will be no real impact in the US, I guess, with regard to GDPR, because it is just a European thing. What's your view on this? Do you have any thoughts on that point?
Yes, absolutely. So sitting over here in the US, I would actually say that the truth is probably the opposite for most organizations. Organizations here, the larger ones that engage in transatlantic commerce, are taking GDPR very seriously and absolutely engaging in, and have been for the past 2 years, engaging in all sorts of preparation for it. But with that said, I'm sure that there are organizations in the U.S. that don't even realize that GDPR does actually impact them, because of course GDPR's territorial scope relates to personal data stemming from activities in the European Union, but then the obligations follow that personal data wherever it goes. So essentially, personal data originating in the EU that then winds up in the United States as part of even just ordering goods and services, that would still be subject to GDPR and to its obligations. So I think it's something that larger, more mature organizations take very seriously and are paying attention to, even though in the U.S., of course, we regulate privacy and data protection by sector instead of through one omnibus piece of regulation like this.
Sure, great. Well, hopefully that answers that question for our listener there. Drew, let's just get one more question for you before we move to a question that's for Matt. One of our listeners has asked an interesting question. They've said, is a breach which only affects one person still reportable?
Yeah, so that would potentially still be reportable, assuming it met all of the other requirements we talked about as far as being a type of breach that would actually lead to a risk to the rights and freedoms of that data subject. Then even if it only affects one person, still be reportable. With that said, breaches that only affect one person versus 1,000 people are going to have less overall impact most likely, but that's only one factor to look at. So if that one person's if the breach affecting that one person actually had a lot of sensitive data, such as health information about that one person, then it's still going to reach that, probably both thresholds potentially for the high risk to their rights and freedoms.
Sure, great. Thanks for that, Drew. Matt, let's come to you. One of our listeners has posted a question which related to a couple of points you made in your presentation with regards to more companies now looking to spend more money on GDPR programs and programs that will kind of help them with their GDPR preparedness. One of our listeners wants to know, firstly, how do they know they're spending the right amount? And secondly, how can they avoid the problem where they will be giving a lot of investment in the lead up to May 25th, but actually once that's done, they will actually see less funds come their way because execs may think all the work's done?
Well, they're both very good questions, but I'd suggest the first one is maybe not quite the right one to be asking. A lot of people are asking themselves, am I investing the right amount in responding to GDPR? What I'd say as a challenge to that is, instead of asking that question, say, am I doing the right things for GDPR? If I feel I'm doing the right things, then I'm spending the right amount. And a good test of that is whether you are really ready. So to take incident management as an example, have you actually tested those plans? Do you know that you can see what's going on in your network? Do you know what's really happening? Because if yes, then, if somebody else is spending more money than you on that, it is kind of academic. So the first one is to do that. And the second thing there is, the aim of security functions in particular is to be risk managers. And risk means trying to help our organization succeed by managing the costs. In this case, you've got two things to play with. You've got the cost of the controls that you need to be ready for a compliance requirement, and you've got the cost of an incident if it goes wrong. So you should be looking to manage those costs, so you're spending sensible amounts of money to put sensible controls in place that reflect the risk to your data. Other companies may have different risk profiles and they may choose to spend differently. So I'd focus on, do I understand the risks, and are my controls that I put in place, do I know that they're going to work? And when it comes to post-May, I think the key for this is just to recognise the May date is a date where legislation comes into effect. Every single date after that, the legislation applies. It doesn't stop to apply. It continues applying, and our organisations change, so the data that we have changes, the nature of our companies changes, the client's requirements change. It is going to change afterwards. So if we have metrics that we can provide that show our readiness, and we maintain those metrics, we provide an operational dashboard against how our data is, how our incident response is, how our technical security controls are, then it's simply a matter of using that to demonstrate the need to stay on top of it. And I think that's perfectly achievable.
Great, thanks so much, Matt. Dee, let's have one question for you quickly, just if we've got time. What would your be advice with regards to the least intrusive way to test readiness for a data breach response?
Yeah, that's a great question. So, well, I'll start with the ideal and best way to test your response, which might not necessarily be the least intrusive. So really, end to end, take your response plan and effectively test it out of hours on your production environment and simulate an event, right? So that is the ideal way to test, but obviously intrusive. On the other side, I mentioned this a couple of times in the presentation. What we see customers do is effectively simulate in a tabletop environment a breach, for instance. So take a scenario which would be high impact, and it's determined to be high impact from a data subject standpoint, but also the organizational standpoint. Work out an attack path that is feasible, and effectively replay that, but without actually attacking the organization, but replay that within a closed room, and bring together the key stakeholders, your response guys, your executive team, the legal and PR team who would typically be involved in something like this, and obviously with limited knowledge of what the scenario would actually be. And yeah, just see how it's often very interesting to see what unfolds in that environment. But it's a good way to test, how the combined team would respond, and if the mechanisms from a plan perspective you put in place actually worked or not. So I think that would be my recommendation.
Sure, great, thanks Dee. We've got time for just one last question quickly. So Drew, let's come to you for that one. One of our listeners wants to know, if our companies utilise hosted services, should we be asking those vendors providing those hosted services for some type of GDPR certification?
Sure, thanks for the question. At this point, there really is no such thing as a GDPR certification. So in the future, what the GDPR allows for are certifications in place of adequacy decisions for international transfers. But in terms of just an organization having any sort of official certification for GDPR compliance, it actually goes back to what Matt was talking about, where this is an ongoing iterative process to always be meeting your obligations for data protection. So there is no such thing as a stamp of approval for certification. So instead, when validating third-party vendors, what you want to ensure is that the vendor is, first of all, aware of their obligations with regard to GDPR. So presumably, you would be using them as a data processor. So you want to ensure that. You want to ensure that the vendor takes security seriously. So whatever type of data you're giving them, you want to make sure that they have security mechanisms in place to protect that data, and that those are appropriate for the type of data. And then you want to make sure that that vendor, if you're using a vendor outside of Europe, and there's going to be an international transfer, you want to make sure that they adhere to one of the many co-equal transfer mechanisms, such as the privacy shield if they're in the U.S., standard contractual clauses, or they are in a country recognized by the European Commission as being adequate, or even using binding corporate rules. And so providers that demonstrate that sort of maturity are going to be the providers that are going to be much more likely to be helpful to you with your own GDPR obligations, because the majority of the obligations really flow down to the data controller, and then the data controller is giving instructions to the processor to help them make sure they're meeting those obligations. So security really is key when choosing a third-party provider. But the GDPR certainly is not a data localization law and does not stop data flows. It's just all about the protections following the data.
Great, thanks so much, Drew. Well, that's all the time we're going to have for today, I'm afraid. So a big thank you to Drew, Matt and Dee for joining us, and obviously a big thank you to our audience for joining us too. For details on upcoming webinars, please do see our website. Our next webinar will actually be taking place later today, and we're going to be looking at the state of cloud security keeping pace at scale. So we look forward to you joining us for that if you can. Please don't forget there will be a recording of this webinar that will be available on our website very shortly. Please also do rate the webinar and tell us what you liked, and you can let us know of anything you'd like to hear from us in the future. But without further ado, I'll say one last thank you for joining us, and we'll end the session there.